Welcome to the SARS Tax Practitioner Readiness Program, Module 1. The learning objective for Module 1, you are required to understand the role that you play as a registered tax practitioner in advancing voluntary compliance. We would also expect of you to understand how the legislation, the code of conduct, and the recognition criteria for controlling bodies influences your conduct, the advice that you provide your clients, and the consequences of non-compliance. There are three sources of information, or three sources that regulates the conduct of registered tax practitioners. They are not exactly equal, but they all play a vital role in regulating your conduct as a tax practitioner. The first source is the Tax Administration Act itself. Now that is the law, as they say. And obviously you need to understand that law, what it contains, and also understand how it regulates your conduct. The second source would be the code of conduct of a controlling body that you are a member of. Now, remember, each controlling body has its own code of conduct. However, there are minimum requirements that each controlling body has to adhere to. Once more, you need to understand that this code of conduct needs to be adhered to. The third source, well, that is the criteria document for the recognition of controlling bodies. Within that document, SARS spells out what it requires from tax practitioners themselves. It indicates what does SARS require from controlling bodies themselves. So all three parts forms a bigger whole. However, the Tax Administration Act, as we indicated earlier on, is the most important. The Act itself covers sections from section 239 to sections 243, and these sections focus on different aspects of the law that tax practitioners need to abide by. Now, by understanding the application of the law, it plays an important role in how you conduct yourself with your controlling body, with SARS, and with your clients. And understanding its impact, well, hopefully it will make you think twice about certain forms of conduct. You can find the full extract of the Tax Administration Act on the SARS website or online. Let's focus now specifically on the Tax Administration Act. We'll just give a brief overview of the sections. So section 239 spells out the various definitions. That is the definition of a controlling body, a recognized controlling body, as well as who a registered tax practitioner is. Then we have section 240. Section 240, sub 1, focuses on the registration requirements. Section 240, sub 2, speaks about exemptions to registration or exemptions from registration. And then section 240, sub 3, talks about the preclusions from registration. However, section 240 needs to be read in conjunction with section 234 to sections 238 of the Tax Administration Act, which focuses on specific criminal offences, and we will come to that later on in the presentation. And then section 240A spells out the requirements that controlling bodies need to meet in order to be recognized by the Commissioner. Section 241 speaks about complaints to a controlling body, and it's important that you need to understand that there are certain criteria that needs to be met before a complaint can be submitted to a controlling body. However, please keep in mind that because we have a section like this, it means that SARS or taxpayers can actually report you to your controlling body or to SARS because of the conduct, because of your conduct, or because of the kind of advice that you gave them. Section 242 talks about the disclosure of information regarding a complaint, and Section 243 talks about the complaint that has to be considered by a controlling body. So, Section 239, as we indicated earlier on, talks about definitions. The first definition is that of a controlling body. Now, the Act says that it means a body that has been established, whether voluntarily or under a law, with power to take disciplinary action against a person who, in carrying on a profession, contravenes the applicable rules or code of conduct for the profession. Essentially, there's no limitation on who a controlling body is. If you are established voluntarily or under law, and you can take certain disciplinary action, well, then it's a controlling body. For example, a doctor maybe has to belong to a particular body that is considered a controlling body. However, later on in the Act, we do specify which are the controlling bodies that we recognize. Then you have what is called a recognized controlling body. So yes, we give the broad definition of a controlling body, and then we give a more narrowed version of a recognized controlling body. And that means a controlling body that is recognized by the Commissioner under Section 240A of the Tax Administration Act. And then we have what is a registered tax practitioner. Well, it's a person registered as a tax practitioner in terms of Section 240 sub 1. So a person can therefore only be a tax practitioner if he is then registered with a recognized controlling body and SARS, or a controlling body in specific instances and SARS. So this means that he would have to meet all the requirements that are set out by the controlling body, successfully completed the SARS Readiness program, and does not fall under a category of Section 240 sub 3. If you don't meet the requirements, then you cannot submit returns or assist taxpayers on behalf of others, especially not for a fee. It's important that you understand this, ladies and gentlemen. You cannot, if you are not appropriately registered, you cannot render the services of a tax practitioner. If, however, you are registered with more than one controlling body, well, then you need to inform SARS, who is your primary controlling body. And the registration process only allows one controlling body. Let's now look at Section 240, which talks specifically about the registration of tax practitioners. Now, Section 241 says that an individual may register as a tax practitioner. So it's a natural person. It also outlines which bodies they need to register with, as well as the obligations. Section 240 sub 2 says that there is an exemption from registration. In other words, who may not register as a tax practitioner and why. So let's give an example. Let's say the tax advice that you are providing, or the service that you are providing, which is a tax service, is incidental to the provision of another service, but that other service is in actual fact the main service. There is then no requirement for you to register as a tax practitioner. Let me say that again. You are rendering a tax service. However, the tax service itself is incidental to the provision of a main service. Let's see if we can make a practical example for you. If you have an insurance broker who sells retirement annuities, the main service would be the brokerage, the broking and selling of the retirement annuities. However, this broker also assists his clients in submitting their tax returns. Now, it's not required of him to register as a tax practitioner because the main service is broking. Also, employees of a tax practitioner who works under the supervision of a tax practitioner will also not be required to register as a tax practitioner. So let's say you register today, you establish your practice, by next year it grows, you have 3 or 4 individuals working for you. They do not need to register as a tax practitioner because they are not charging a fee for the service. You are charging the fee. They are employed by you. However, if that staff member has their own clients that they are charging a fee for in rendering a tax service, then they would have to register as tax practitioners. But if their only function is being employed by yourself, then there's no requirement for them to register as a tax practitioner. Section 243 lists preclusions from registration. So you may not be registered as a tax practitioner if you have been convicted of a criminal offence or any offence involving dishonesty in the preceding 5 years, or you have been removed by a controlling body due to misconduct in the preceding 5 years. SARS may also deregister a tax practitioner if he or she was convicted of a criminal offence or any offence involving dishonesty or continuous tax non-compliance. Now, let us just pause here for a moment. The Act says that you might meet all the qualifications to being a registered tax practitioner. You might even be, you'll be a member of a controlling body. However, if you have been convicted of a criminal offence, so the offences are very specific, and you need to just consider, refer to the Act in order to identify what these criminal offences are. If you have been convicted in the last 5 years, you cannot register as a tax practitioner. You cannot render the services of a tax practitioner. You cannot charge a fee for your services because you're not a registered tax practitioner. Important as well, even if there was no criminal offence, but your controlling body instituted disciplinary action against you, and because of the disciplinary action, you were removed as a member due to misconduct. In those instances as well, you will be precluded from registering it as a tax practitioner. We may also deregister you as a tax practitioner if you have been convicted of a criminal offence or any offence involving dishonesty. And you note, included in that is continuous tax non-compliance. So if you as a tax practitioner are non-compliant in your personal right, we can in actual fact deregister you as a tax practitioner. So it's important that you understand the implications of being non-compliant. Usually we say the mechanic's car is in a worse condition than the clients whose cars he is servicing. Please do not fall into that category. Ensure that your tax affairs are up to date, that it is in order, because if it is not, we could deregister you as a tax practitioner. The Act even goes further to say that if there is a criminal case that is pending, and during the criminal case, you repeat the offence, so you haven't learned there's a case, but you haven't stopped, SARS may stop any registration, or we can suspend your registration until the end of the case. And then we have section 240A that talks about the recognition of controlling bodies. Now here is a list of controlling bodies as at June 2022. There are certain controlling bodies that are statutory bodies that are automatically recognized by SARS. Those two are the Independent Regulatory Board for Auditors, namely IRBA, the Legal Practice Council, which is LPC, and then there's a list of controlling bodies that has to be recognized or apply for recognition to SARS. Now, please consult our website to get the most recent list of controlling bodies. They are in no particular order of importance. So we'll start off with the Chartered Institute of Management Accounts, commonly known as CIMA, the Chartered Governance Institute of Southern Africa, which is CGISA, the Financial Planning Institute, which is the FBI, the Institute of Accounting and Commerce, which is the IAC, the SA Institute of Chartered Accountants, which is SICA, the SA Institute of Professional Accountants, which is SIPA, the SA Institute of Taxation, which is SITE, the Association of Chartered Certified Accountants, which is ACCA, and the Southern African Institute for Business Accountants, which is SIBA. As previously indicated, please consult the most recent list of recognized controlling bodies on the SARS website. So if you're not a member of one of these controlling bodies, you will not be allowed to register with SARS as a tax practitioner. Let me say that again. If you are not a member of one of these controlling bodies, you will not be allowed to be registered as a tax practitioner. What about the reporting of unprofessional conduct? You need to keep in mind that the entire regulation around tax practitioners is for the benefit of the taxpayer. In other words, the client that you represent. It is for their protection. So, of course, there has to be a section within the Act that looks at the reporting of unprofessional conduct. And this is where Section 241 comes in. Now, what are some of the complaints that we have been dealing with over the last few years? Well, strangely, the withholding of taxpayers' e-filing profiles, which prevents them then from being tax compliant. And usually this happens when there is a disagreement between fees that has to be paid. And tax practitioners feel that they can withhold the e-filing profile of the client, but this is unprofessional. If there's a failure to perform your tax practitioner duties, in other words, not informing taxpayers timeously, not submitting returns timeously, even though you've told taxpayers that you have submitted, all of that is considered unprofessional conduct, and it's reportable offences. The fraudulent submission of returns, for example, are you submitting no returns for a taxpayer while knowing that the taxpayer is in actual fact trading? There was a recent court case where a company that was doing business with the state was found guilty because it was submitting no returns. However, the practitioner that was assisting that, pardon me, the practitioner that was assisting that taxpayer was also found guilty for aiding and abetting the client in submitting the no returns. He should have known better. What about fabricating SARS letters in order to charge taxpayers for additional fees? I am not making this up, ladies and gentlemen. These are cases that we have personally worked on over the last few years. What about the charging of a contingency fee? In other words, you're charging a percentage of a refund to taxpayers. This is not allowed. It's considered unprofessional conduct. Abusive behavior towards SARS employees or even to the taxpayer themselves. We've had a number of cases where that has happened, and tax practitioners have been reported to SARS and then in turn to their controlling bodies. What about the use of the SARS trademark or logo? Well, you cannot use the SARS logo in advertising. You cannot, it's a trademarked product. So you can't even use the words SARS or e-filing for that matter. These are all trademarked items. So please do not use our trademarks, do not use our logos. Don't try to give the person the impression that you have a relationship with SARS. Tax practitioners that have been deregistered, we look in our section, due to the convictions, they are sentenced to a period of imprisonment exceeding 2 years without the option of a fine. There we are talking about theft, fraud, forgery, or the uttering of a forged document, offences involving dishonesty, serious tax offences. You need to understand that if you are guilty, if you are found guilty, and you have been convicted, you are out of the system for 5 years. 5 years, ladies and gentlemen. You have a lot more to lose than what your client has to gain by requesting of you to submit incorrect information on their behalf. Just to give you some information, I mean, over the last, just in the last financial year, we deregistered 132 practitioners just because of their personal non-compliance. And that was in terms of Section 243D of the Act. And then even if you do, you are rehabilitated, let's use that word, and your tax affairs are now in order, you still are out for a period of 6 months before you are able to re-register. So please keep in mind that we are not preventing you from earning a living. Your actions determines whether we are preventing you from earning a living. So please ensure that your conduct is at all times above board. What about the lodging of a complaint to a controlling body in terms of Section 241? Well, Section 241 says that a senior SARS official would submit a complaint to a relevant controlling body relating to the conduct of a tax practitioner regarding his or her conduct. Now, here we are talking about a controlling body as in the two statutory bodies. So Section 241 deals with those specifically. Then we have Section 241(2), where it says that a complaint could be lodged to a controlling body in terms of the section, in terms of the section, but this will be to a recognized controlling body. Those would be the controlling bodies that had to apply for recognition to SARS. And here it talks about they acted outside of the law, unlawfully submitted tax returns, gave wrong information, gross negligence. And you will notice that these terms, both in Section 241(1) as well as 241(2), they are very broad. And because they are broad, you could easily find yourself falling into any one of these categories. Unlawfully submitting returns. You know, do you have a power of attorney to submit a return? Giving wrong information. Well, any information that you give could potentially be wrong, you know, if you don't have all the facts. So please be very careful when considering the kind of advice that you give your clients. Section 242, however, talks about the disclosure of information with regard to a complaint. And what it basically means is that, as you know, Section 69 of the Act says that SARS cannot share taxpayer information with anybody outside. However, Section 242 says that if it is with regard to a complaint, we can share that information with an outside party, especially a controlling body. And then Section 243 sets out complaints that can be considered by a controlling body. Okay, so the complaint has to be considered, must be considered by the controlling body according to its own rules or codes of conduct. So there must be a process in place that a controlling body has to follow when considering these complaints that have been lodged in terms of Section 241. It's important, however, to remember that Section 241 and Section 242 is aligned to the code of conduct of your RCB anyway. Okay, so it's not that it will be in the law, but not in the RCB's code of conduct. And so Taxpayers or clients of a practitioner may submit a complaint to SARS and the RCB, either one. If the RCB finds you guilty, the RCB will then notify SARS accordingly. A tax practitioner who takes on a new client from an existing client, you may also submit a complaint to SARS if you notice that the previous tax practitioner was in violation of the Act or Code of Conduct. Remember, this is very much a self-regulatory environment. So if you notice something, you're part of a broader tax practitioner community. So it will be required or expected of you that if you notice something is not right, that you report it to SARS, because chances are that that practitioner is doing the same thing with other clients that he is representing. Practitioners are also encouraged, recommended and encouraged to report any tax practitioners who are in breach of the legislative requirements, including the necessary codes of conduct of controlling bodies. Now, we mentioned earlier on, pardon me, we mentioned earlier on sections 234 to 238 of the Tax Administration Act. And these sections outlines what kind of criminal offences can be applied to specific acts. So section 234 talks about the issuing of false documents, a failure to notify SARS of changes, failure to register as a tax practitioner, or the retaining of proper records. All of those kind of offences falls under section 234. And linked to each section, there will be a period, if you are found guilty, a conviction period. So obviously, the further down the line you go, the greater the penalty or the fine. Section 235 talks about the submitting fraudulent documentation, making false statements in order to defraud the state. Section 236 looks at a person who contravenes the section secrecy provisions from section 267, from section 67 all the way through to section 70. Section 237 looks at criminal offences relating to filing a return without proper authority. So that is where you have no permission, there's no power of attorney in place, etc. And then section 238 says that a person who's charged with a tax offence may be tried in respect of that offence by a court having jurisdiction within any area in which that person resides or carries on business. So it's important, ladies and gentlemen, that when you read the regulations governing tax practitioners, you also need to read it in terms of this criminal offences. However, I am pretty sure that you will not be giving advice that would be in contravention of these sections of the Act, which means that none of your clients will be reporting you to SARS. At least that is our hope. That brings us to the end of module 1.2. We hope that you now understand how important it is that you understand the different codes of conduct, the different sections of the legislation, as well as the criteria document regulating tax, recognizing controlling bodies. Please make sure that you revise the section, go through the Act itself, ask your controlling body for a copy of the Code of Conduct, and make sure that you understand it, because only by understanding will you understand the implications of what you are doing. Thank you for listening.